Good morning, everyone. My name is Suzanne Templin, and I coordinate the webinars for Hausmann Johnson Insurance. I would like to welcome you to today's webinar, Examining Common Pitfalls in Construction Contracts, presented by John Templin and Sammy Schacht. Today's webinar will run about 30 minutes, and after the webinar, we'll have a question and answer session. If you have a question during the webinar, feel free to type it into the question feature, and John or Sammy will address it during the Q&A portion. After the webinar is over, there will be a short survey we are hoping you can fill out for us. Please be aware that this webinar is being recorded and will be available for review on the webinar archives of our website. If you do not want to participate in a recorded webinar, you may want to close the application at this time. You will receive a follow-up email from GoToWebinar with a link to the recording and the presentation slides. I would now like to introduce you to our presenters for today's webinar, John Templin and Sammy Schacht. John grew up around insurance. When he was young, his grandfather owned an insurance agency in Peoria, Illinois. Now he is the one that clients put their trust in to protect the businesses that they've built. John enjoys making clients of Hausmann Johnson Insurance aware of the risks that they face and teaches them how to address those risks so that their businesses can continue to thrive. John is extremely detail-oriented when it comes to reading contracts and coverage forms and is very effective at making clients aware of unfavorable contract language in leases and construction agreements. He likes to dive in and help solve a client's problem right alongside them. Clients appreciate the way John is able to advocate for them in a way that protects their interests and respects their professional relationships. Sammy Schacht is an attorney in the Madison office of Hush Blackwell and a member of the firm's real estate, development, and construction team. Sammy represents contractors, developers, and designers in all phases of construction projects, providing clients with comprehensive transactional and litigation services to help manage risk and resolve disputes. Prior to joining the firm, Sammy worked for a trade association representing contractors and in-house for a national general contractor. They both have a wealth of knowledge on this topic, and we are very thankful that they could share some of their wisdom with us today. Welcome, John and Sammy.
Hello, and thanks for joining the webinar. Since we've designed this program, there we go. You good? Yes. All right. So since we've designed this program to be short and sweet, I've identified what I consider to be the most critical sections of construction contracts. These are the sections that I believe present the biggest risk to your bottom line if the project goes south. So today I'm going to cover the warranty period, consequential damages, no damages for delay, and indemnification. These issues that I discuss are by no means the only issues that you should look out for, but I do consider them to be some of the most important. The goal today is to deepen your understanding of these important issues, which will in turn enable you to more effectively identify and negotiate critical provisions in your construction contract. Just a quick note, for my portion of the presentation, I'm going to speak in terms of the owner-general contractor relationship, but most, if not all, of these same principles are also applicable when negotiating agreements between contractors and subcontractors. What you see on the slide here comes from the Standard Form AIA A201 General Conditions. This specifically relates to the contractor's obligation to correct defective work, which applies for a period of 1 year after substantial completion. I've found in my practice that many contractors interpret this language to mean that after this 1 year period has passed, they've satisfied all of their contractual obligations and their liabilities with respect to the project are over. However, for reasons that I'll explain, that interpretation is not correct. In reality, you're potentially liable for projects for much longer than the 1 year after substantial completion. This liability is the result of a statute that we refer to as the statute of limitations. The statute of limitations establishes a time period during which legal claims may be brought. Once the time period is passed, no claims can be brought, even if that claim is entirely legitimate. Just as a note, today we're talking about statute of limitations claims in Wisconsin, and more specifically those relating to breach of contract and tort claims. Statutes of limitations vary by claim and by state, so claims beyond those discussed here and claims arising in different states may have different parameters. The statute of limitations for breach of contract claims is 6 years after the cause of action accrues. The way that accrues is defined is going to be critical in our discussion here. Accrues in this instance means when the breach occurs. So it doesn't matter whether or not the claimant knew that the breach occurred or when the claimant found out about the breach. It only matters that when the breach occurred. In construction, contract breaches are presumed to have occurred by substantial completion. After those 6 years have passed, you're generally free from liability for breach of contract claims. The statute of limitations for tort claims varies from breach of contract claims in one very important way. But before we get into that, I want to just briefly explain what a tort is. A tort is a civil wrong independent of contract which arises out of a breach of a legal duty owed to persons generally. A common example of a tort in construction is negligence. In the context of a negligence claim, a party is liable in tort when it has failed to behave in a manner that's expected of a quote-unquote reasonable person. I've put an example of a negligence claim on the slide here to help you understand this. A roofing subcontractor uses materials other than those specified. 2 years later, the roof starts leaking, which causes water damage to the building. This is considered a tort because a reasonable contractor would have used the materials specified. Similar to breach of contract claims, the statute of limitations requires that tort claims are commenced within 6 years after the cause of action accrues. But for tort claims, the law defines accrues differently. Accrues means the date that the injured party discovers or should have discovered the injury. So for tort claims, there's a knowledge element. This knowledge element can be a determining factor between having a claim and not having one. Think about the roofing subcontractor example that I used on the previous slide. Say that instead of discovering the defect in 2 years, the owner discovered the defect 8 years later. Well, the owner no longer has a breach of contract claim because that expired at 6 years, but you would have a tort claim. This knowledge element can scare people at first. What happens if the defect is discovered 20 or 30 years from now? Are you liable for that? Thankfully, the answer is no, due to the statute of repose. The statute of repose puts a limitation on tort claims. The time period to bring this claim is 10 years. So you have 10 years to discover the claim. If you fail to discover the claim, by then you're out of luck. However, there is an exception to this 10-year limit. If you sustain damages during the 8th through the 10th year, you get an extra 3 years to commence the action. So going back to the initial question that I presented, how long do you actually remain liable for claims on a project? The answer is 13 years. So what should you take away from this? The so-called one-year warranty period is a myth. Contractors remain liable for claims for 13 years. As a result, project records should be maintained for 13 years. You want to have all the information possible available to you if a claim is brought against you. Finally, consider attempting to limit your liability to the owner contractually. For example, include a clause that limits your warranties to those in the contract and disclaims all other warranties. If you can't get the owner to agree to that, perhaps you can at least shorten the warranty period provided at law. We're again looking at the AIA A201 standard form language, this time relating to consequential damages. As you can see, this clause provides for a mutual waiver of consequential damages, meaning that neither party is liable to the other for these kinds of damages. This provision in the AIA standard form is still a pretty good provision. Unfortunately, however, what you see on this slide is the type of consequential damages clause that we're seeing more and more. Here, the contractor waives consequential damages but remains liable to the owner for these same damages. People often ask me how important this clause is or how important a lack of such a clause is in a contract. In my opinion, this is one of the most important provisions in a construction contract, especially in prime contracts. To understand why this provision is so important, you need to know what consequential damages are. There are two types of damages, direct and consequential. Direct damages flow naturally and necessarily from the breach, while consequential damages are economic harm beyond the immediate scope of the contract. These aren't great definitions, but they're about the best that the courts have provided us. When you have a waiver of consequential damages clause, the difference between direct and consequential damages becomes highly litigated. Unfortunately, all of this litigation hasn't resulted in a more clear definition. What we do know, though, is that courts consider the remoteness of the loss to the risks contemplated by the contract. As a general rule of thumb, the following tend to be considered consequential damages: lost profits, interest and finance charges, loss of use, business or reputational losses, and loss of productivity. Lost profits is a huge one in the construction context. Also in the construction context, the owner most often claims consequential damages when a project is delivered late. What we often see in these instances is that the risk presented by consequential damages far exceeds that contemplated by the contractors when they enter into an agreement. To illustrate this point, I've included a real-life example from a case in New Jersey. Perini was the CM on a hotel casino project in Atlantic City. The contract provided for a fee of about $600,000, but the contract did not have a waiver of consequential damages provision. And in the absence of a waiver provision, you are liable for consequential damages. When the project was delivered 4 months late, the arbitrator found the CM liable for over $14.5 million in consequential damages, primarily in lost profits. So you can see how consequential damages often don't align with the risks contemplated at contract execution and how substantial consequential damages can be. These are the kinds of damages that could force a smaller contractor to close its doors. What I want you to take away from this is that consequential damages present a risk that often far exceeds the risk contemplated when entering into a contract. Make every effort to limit your liability for these losses. Limiting your liability ideally includes two elements. One, the inclusion of a waiver of consequential damages from the owner, and two, a specific definition within that provision of what constitutes consequential damages for clarity. If you provide clear examples of how the parties define these kinds of damages, that will hopefully reduce the possibility of litigation of this clause should a dispute arise. I also want to touch briefly on no damages for delay clauses. People generally know what a no damages for delay clause is. The provision that states that when you, as a contractor, are delayed by causes beyond your control, your remedy is limited to an extension of the contract time to complete the work. But do you know what kinds of damages you're actually waiving? Primarily, you're waiving your right to general conditions costs. These include supervision, project management, utilities, etc. General conditions costs are the most obvious and measurable damages that you'll suffer, because each day that you have to be on the project longer than you expected, you incur additional costs that you didn't plan for when you bid the project. There certainly can be certain other damages like lost opportunity costs, but these are much harder to prove. From a fairness perspective, it doesn't make much sense that when the project is delayed for reasons that you had nothing to do with, you're expected to foot the bill for those extra costs. But that's exactly what a no damages for delay clause obligates you to do. Generally, the reason that owners like these clauses is because it can often be difficult to determine who's at fault for delay. There may be multiple causes, which makes assessing fault hard, so they just flow that risk down to you. So what can you do? No damages for delay clauses shift the risk and costs of uncontrollable delays onto the contractor. Whenever possible, remove no damages for delay clauses from your contract, or at least push for modifications. The most common modification is the clause that permits recovery of additional general conditions costs incurred for delays beyond your control. In that instance, consider whether it makes sense for you to agree to an amount for those costs now, perhaps on a monthly or weekly basis, or whether you want to wait until the delay occurs to negotiate those costs. You could also consider modifying the clause to allow damages if the delay is caused by the owner or the architect. Final item that I'm just going to touch on briefly before I turn it over to John is indemnification. Indemnity clauses are often broken down into three different types. There's broad form indemnification, which requires the contractor to indemnify the owner for all loss, even if caused solely by the owner's negligence. Intermediate form, which requires indemnification except to the extent caused by owner's sole negligence. And limited form, which requires you to indemnify the owner only to the extent of your own negligence. Many owners are pushing for broad form indemnification lately, and we're also seeing a push for owners to require indemnification for claims beyond those that just result from personal injury or property damage. Broad form indemnity is impermissible in many states, but it is permissible in Wisconsin. I think most would agree that it isn't the most fair to require the contractor to indemnify the owner for a loss that the owner was entirely responsible for. But a contract is first and foremost a risk management tool. And as a business person, what you care about when you sign on the dotted line is that you're comfortable with the amount of risk that your company is taking on in that contract. One way that you can limit your risk is through insurance. So the question that you really want to ask when it comes to indemnification is not what form of indemnification is fair, but what form of indemnification is insurable. If it's properly tailored, even broad form indemnity can be insurable. And with that, I'm going to turn it over to John, who's going to talk more about how you can tailor your indemnification provisions to limit your risk exposure.
Excellent. Thanks so much, Sammy. As we change gears here, Sammy just looked at it from the owner to general contractor or owner to construction manager, those sorts of contracts that you see with the AIA most frequently. My focus is going to be on subcontract agreements primarily. Again, similar to Sammy's portion, you'll find that there are quite a few principles here that also apply to the owner-general contractor relationship. So some of the things I'll be talking about from an insurance standpoint are how you can align your indemnification requirements with the ISO General Liability Additional Insured language. ISO is the Insurance Services Office, and while most carriers do have forms that are a little bit different, ISO tends to be the standardized language that everybody starts from. And these are often the forms that when you sign a subcontract agreement, you're going to see specifically listed and required. I'm going to help you recognize some risks that are in the indemnification agreements, as Sammy alluded to, some that go beyond the scope of what an insurance policy can cover. With no offense to Sammy, because I think she's one of the few attorneys that does understand it. Oftentimes, attorneys will ask things of the insurance industry that aren't reasonable. Finally, we'll look at how to take a look at how you can transfer all the risk that you've assumed in your contract to the lower tier subcontractors. So if you've got a sub-sub, things to keep in mind that you might want to actually get a subcontract agreement instead of just purchase orders. And finally, we'll wrap it up with some strategies that you can use to protect your business and overall develop some procedures that will help you protect your interests. Okay. So as Sammy mentioned, I wanted to revisit this and put it in an insurance perspective. This table is going to appear again after we talk about these specific forms. But in broad form indemnification, you're fully indemnifying an upstream party, a general contractor, an owner, potentially both, more than likely both, for any losses, including the sole negligence of what's called an upstream party. If they're subcontracting you, we'll call them upstream. If you're signing the contract, we'll call you the downstream party. Okay? Intermediate form, you'll indemnify fully for any losses when caused at least partially by you. Another way to put how Sandy talked about it previously. So if you're 1% responsible, you're going to take up the responsibility for all the loss. And then finally, take a look at limited form, where you're only going to indemnify to the extent of the loss caused by you. As Sandy would point out, when these things go to court, courts like to assign percentages to who's negligent and who's responsible. So if you're 50% responsible under a limited form, you're only picking up 50% of the loss. Right? We'll get into the corresponding ISO additional insured forms. We'll revisit that after we talk about them. And we'll also revisit the additional insured language that appears on those forms. We'll start off with broad form additional insured, and that's the Insurance Services Office, CG 2010, 11 of 85, or a combination of the CG 2010 and CG 2037, 10 of 01 editions. What you'll notice as we take a look through here, the older the forms are, the broader the coverage is. As time goes on, these forms get litigated, they get interpreted in ways that the insurance companies don't fully intend, and then revisions are made. So this is broad form indemnification. The key phrase we're looking for is arising out of. Keep in mind that some carriers are a little bit more reluctant to offer this language, as again, you're picking up the sole negligence of an upstream party, and that's something that the carrier can't know who you're signing contracts with and who you're doing business with. So what this form looks like, I've just highlighted the key phrase here. You're insuring the upstream party for liability arising out of your ongoing operations. We take a look at the next revision, and this is what you'll see most frequently, a requirement for the CG 2010, 07 of 04, and the CG 2037, 07 of 04. This gets into more of the intermediate form, again, where if you're 1% responsible, you're picking up 100% of the loss. And it's caused in whole or in part is the key phrase that we're looking for. Again, I've highlighted that in the CG 2010, 07 of 04 edition. That caused in whole or in part is the key phrase. There are also some limited form additional insured languages. Again, we're looking at this from a Wisconsin perspective. As Sammy mentioned, Wisconsin allows for broad form indemnification, but there are other states that determine broad form to be against public policy and only allow intermediate form, or in some cases limited form in construction contracts. For instance, I believe Minnesota and Illinois are both limited form. So the ISO 2010-04-13 and the 2037-04-13 can restrict itself down to limited form in some states. The 2013 revision limits the dollar amount of the additional insured coverage to the limit that gets specified in the contract. So say you've got a $2 million per occurrence policy, but only $1 million is required in the contract. $1 million is all the additional insured coverage that the additional insured endorsement will provide. And it also limits the scope of additional insured coverage to state law. Again, this is not applicable in Wisconsin. It is applicable in some other states where you might be working. There are some carrier-specific proprietary forms that are intending to be only limited form. And the language I've seen most frequently there, I'm not going to pick on anybody, but I've seen a few where the simplest way to put it is that it's if and only to the extent that. So here I've excerpted the CG 2010-04-13. Again, note that we still have the cause in whole or in part by language, and then the modifications down at the bottom. The insurance afforded to the additional insured only applies to the extent permitted by law. So in states where anti-indemnification statutes are on the books, this is going to narrow down to whatever the law states. And then finally, if coverage provided to the additional insured is required by a contract or agreement, insurance afforded to the additional insured will not be broader than that which you are required by the contract or agreement to provide. So good summation there. Now that we might have these form numbers make a little bit more sense to us, something that might be a good chart to have on hand as you're reviewing the insurance requirements internally, or if you outsource that to your insurance professional, something else to keep in mind. So if you're agreeing to broad form indemnification and you see intermediate form is required in the insurance requirements, should be a big red flag for you, right? Because you don't want to get to a point where you're underfunding a potential loss. So as you look to align an additional insured endorsement in the indemnification requirements, so I recommend you identify the form of indemnification that you're required. Is it aligned with the insurance? If not, push back to have both sections reflect the most favorable language to you. In the case of a discrepancy, you're going to want to make sure that it's resolved to your favor if possible. Other thing I note, this is going to go beyond the scope of what we're going to talk about today, but you should know that most general liability policies do contain a backstop in the form of what's called contractual liability provision. And typical of insurance, you get that coverage in an exception to an exclusion about 12 pages in. But one thing you should know is that for contractors, some carriers do apply endorsements that are actually restricting this coverage. Proper additional insured forms are going to be the best solution, as contractual liability typically is going to require that anything that's paid out for defense costs is within your limit. Any additional insured, that limit's going to be paid in it, or any defense costs are paid in addition to your limits. Another thing that we'll keep in mind as we change gears Here's some of the things that Sammy had mentioned that we're seeing more and more in indemnification agreements that we're finding the insurance industry isn't able to provide. Might seem self-evident, but any regulatory penalties and fines, such as anything you get from OSHA, MSHA, the Department of Labor, insurance typically won't cover any violation of laws. A choice of counsel provision is one that I've seen cropping up from time to time. Now think this through. If your insurance as a subcontractor is what's going to respond, they don't want whoever you're signing this agreement with upstream to have the ability to choose whoever they want defending the insurance company's pocketbook. And so if the insurance company is going to pay, they want to make sure that they're comfortable with the counsel used. Contractual penalties. Again, as Sammy pointed out, consequential damages and delay damages frequently are not insurable under a general liability policy. So it's important to set those things up in advance and figure out how they're going to be handled. But just keep in mind that insurance can't always respond to everything. And finally, this is a phrase that I always love to see, any and all risk. Now, what does any and all risk mean? Keep in mind a general liability policy is going to cover bodily injury and property damage. Any and all risk could certainly fall outside of that into some of these other areas. Taking a look now as you transfer your risk to a subcontractor, or if you're a general contractor, how you transfer the risk from the owner agreement down to your subcontractors. Keep in mind most contracts are going to contain a flow-down provision. And so review your subcontract language against the contract you've signed. Keep an eye out for waivers of subrogation, limits, required coverages, say if you've got a professional liability requirement or a pollution liability requirement. Make sure that you're flowing all those things down. If anything that you don't transfer, you're going to retain. Ultimately, you've signed a contract where you're promising to provide that coverage. And if your subcontractor isn't going to do it, ultimately you're still on the hook. So finally, we'll take a look at a few strategies, just general ideas that I would encourage you to take a look at from both the legal and an insurance perspective. You should decide at the upper levels of your organization what your tolerance for risk is. When do you push back? When do you walk away? If you're taking on a $5,000 job, does it make sense to accept broad form indemnity? Or does it make sense when you're looking at a $500,000 job to accept broad form if you need to? So keep that in mind and communicate it down the line. If you have project managers that are negotiating these things, it's a good idea to know what your organizational stance is on that. Develop a contract review procedure. Now, I know I work with contractors about 95 to 98% of my life. So it's important that you develop a contract review procedure. And I get that it doesn't always happen on this time frame, but ideally, you want the contract before you start work. You want to make sure you're reviewing it thoroughly before you're signing the contract, before you're subcontracting any portion of the work. Again, anything you don't transfer, you're going to retain, and then how you're going to handle any additional insurance costs if they're required. So the main takeaways from my portion, I want you to review what you're signing and the liabilities you're assuming in the contract, and to identify any internal or external resources that can help your contract review process. Any internal specialists you have. Who's responsible on the front lines? Who's going to be reviewing the scope of work? Who's going to be reviewing some of the other provisions that Sammy talked through? Who's going to review the insurance section of it? So keep that in mind. Who are the internal specialists? Ideally, if I were your insurance agent, I'd want to see every contract you sign before you sign it. And if it gets to a point where there are a few things that you want to look at that Sammy has mentioned, know when to get an attorney involved. Identify who you'd like to work with. And that puts us right about at 9:30. So we'll open the floor up to questions.
Great. So we have a question that just came through. I encourage all of our attendees to use the question feature to type in their questions. We had a question come through that said, are you aware of any plans to outlaw broad form indemnification in Wisconsin?
So I'll jump in on this one. I am not aware that anything's in front of the legislature. I don't know that it's been looked at too much from a legislative perspective, but we are definitely an outlier in the Midwest. I think it's, say, Illinois, Minnesota. Iowa does still allow broad form, if I'm remembering off the top of my head. But no, Wisconsin is going to stay broad form at least for the immediate future. Hopefully longer term it's going to get in line. So I want to say it's about 38 states now that have at least some form of anti-indemnification statute.
We'll go ahead and leave this information up on on your screen so that if you find that as you're reviewing this information that you do have questions or comments for either Sammy or John, they would encourage you to reach out to them. You can use their email addresses that are listed there, or you can direct dial them at these phone numbers. We'll give you a few more minutes to enter any questions, and then we'll go ahead and end the webinar. I want to thank everybody right away for joining us today, and I want to thank John and Sammy for sharing this information, because I know that contracts can be very overwhelming and are a huge part of all of your projects that you're doing around your state. And with that, I think we'll go ahead and end it. Thank you, everybody.